Hello, my name is Adrian Lively. I'm a disputes partner at Osborne Clarke. I'm also a mediator. Welcome to this video. It's part of the series called Straight to the Point of Dispute Resolution. In a recent video, we looked at the regime for resolving tax disputes in the UK. Today, I want to look at another separate process that's available in the UK, and it involves the resolution of disputes regarding the registration of trademarks. These are disputes which are dealt with in the UK Trademark Registry. I'm lucky to have with me today Richard May, who's an Associate Director in Osborne Clarke's Intellectual Property Department. Richard, welcome to Straight to the Point of Dispute Resolution. Can I kick off, please, by asking you to clarify what kind of disputes get heard in the UK Trademark Registry, please?
Sure. So there are, the registry is essentially a forum for certain types of trademark disputes. And in the trademark world, there are two types of trademark disputes. There's disputes about use of a trademark, and there's disputes about the registration of a trademark. And it's the latter that the UK Trademark Registry is concerned with. It doesn't have jurisdiction to hear trademark infringement proceedings, which are concerned with the use of a trademark. Those proceedings are the exclusive domain of the courts.
Thank you, Richard. Well, that explains very clearly about the jurisdiction of the Trademark Registry. What I'd like to now consider a bit is what the process of going through a hearing at the registry is like from the perspective of our brand owner clients.
Yeah, I think the first point to make is that there's certainly less demand on clients with registry proceedings when compared to court litigation. And that's because the UK registry is essentially a tribunal, and it is a streamlined procedure. There are evidence rounds, but those evidence rounds are not as burdensome as they are in court litigation. And the key point is that there is no disclosure. It is possible once you get to a hearing that the client, if they provide a witness statement, that they could be requested to give evidence in person, be cross-examined, but that's almost unheard of really in UK registry proceedings. So from that point of view, it's a much more streamlined procedure and less demand on the client. In terms of timings, it is quicker, generally speaking, than court litigation. Straightforward UK registry proceedings can last around 10 to 12 months. And more complex cases don't typically go beyond 18 months.
So is it cheaper and quicker then for?
It's certainly a lot cheaper than litigation. A reasonably straightforward case could be anything between sort of £10,000 to £30,000.
Mm-hmm.
More complex cases, you're pushing a more 40 to 50,000. Which, compared to litigation is significantly cheaper.
And I wanted to briefly ask you whether you have the same remedies available to you in the registry as you do in the courts. Can you, for example, get an injunction?
No, you can't. The remedies are quite different. So there's no ability to ask for an injunction or damages or any of those, account of profits, those types of remedies. The one single remedy that you do get is the removal of the trademark registration.
Okay. And what I always ask people at this stage of these videos, Richard, is if you have any top tips. So this would be, in this case, obviously top tips in terms of how brand owners should approach a process in the trademark registry.
Yeah, I think the one thing to remember is that it isn't litigation. And the registry is not concerned with trademark infringement, and it's not concerned with the use of the trademark, generally speaking. And so what that means is that the actual trading activity of the parties is not typically taken into consideration. That's very much what the court looks at. But the trademark registry essentially makes its decision based on applying a notional test. So what the registry will do is look at the trademark registration that the brand owner is asserting, and it will look at the trademark application that the other party has applied for. And they will, from a hypothetical point of view, look at how those trademarks could be used and determine whether there is any conflict on that basis. And so going back to my earlier point about the fact that there is less impact, I think, on the brand owner to engage in this process. That is a key point, and I think if you do try to approach these things in the same way as you would litigation, then you may unnecessarily involve the client and increase costs and time.
Thanks very much, Richard. That was most interesting. If you have any comments or questions arising from what we've been discussing, please do let us know. We'd love to hear from you, and we love to get engagement. Thank you.